1月28號，按中央人民政府根據《香港國安法》第11條提出嘅要求，向中央提交報告，並喺報告裏邊建議提請全國人大常委會根據《香港國安法》第65條作出解釋，以釐清根據《香港國安法》的立法原意和目的，沒有本地全面執業資格的海外律師或大律師，可否以任何形式參與處理危害國家安全犯罪案件的工作。全國人大常委會今日就《香港國安法》第14條以及第47條作出解釋，我表示歡迎同埋感謝。全國人大常委會嘅解釋說明咗以下幾點：一、香港國安委根據第14條有權對是否涉及國家安全問題作出判斷同埋決定，其決定具有可執行嘅法律效力。香港特區行政、立法、司法等機構，又或者任何組織、個人，均不得干預香港國安委嘅工作，均應尊重並且執行香港國安委嘅決定。第二，特區法院喺審理國安案件，遇到有涉及有關行為是否涉及國家安全，或者有關證據材料是否涉及國家秘密嘅認定問題，應當向行政長官提出並取得行政長官就該等問題發出嘅證明書。上述證明書對法院有約束力。第三，有關不具有香港特區全面執業資格的海外律師，是否可以擔任危害國家安全犯罪案件嘅辯護人或者訴訟代理人呢一個問題，係屬於香港國安法第47條所規定嘅需要認定嘅問題，應當取得行政長官發出嘅證明書。如特區法院沒有向行政長官提出並取得行政長官就該等問題發出嘅證明書，香港國安委根據《香港國安法》第14條規定履行職責，對該等情況同埋問題作出相關判斷同埋決定。香港國安委同埋特區政府會全力落實釋法內容裏邊所講嘅責任。呢一啲工作包括：第一，香港國安委就不具有香港特區全面執業資格嘅海外律師是否可以擔任危害國家安全犯罪案件嘅辯護人或者訴訟代理人，是否涉及國家安全嘅問題，以及應當採取何種政策作出判斷同埋決定。第二，香港國安委會積極履行香港國安法第14條嘅職責，包括：一、分析研判香港特別行政區維護國家安全形勢，規劃有關工作，制定香港特別行政區維護國家安全政策；第二，推進香港特別行政區維護國家安全嘅法律制度同埋執行機制建設；第三，協調香港特別行政區維護國家安全嘅重點工作同埋重大行動。 工作第三，特區政府會評估風險，積極考慮法律執業者條例有關專案認許條文嘅修訂工作，強化維護國家安全嘅制度保障。第四，特區政府會履行《基本法》第23條嘅憲制責任，同埋香港國安法第7條嘅規定，盡早完成有關維護國家安全嘅本地立法，並且按照香港國安法實施同埋維護國家安全嘅新形勢、新要求，完善本地相關法律，充分運用本地法律解決香港國安法實施裏邊遇到嘅有關法律問題，有效防範、制止同埋懲治危害國家安全嘅行為同埋活動。全國人大常委會根據憲法同埋香港國安法賦予嘅權力，解釋香港國安法嘅條文，明確咗相關條文嘅法律含義，確立原則，確保特區各個機關更準確履行香港國安法規定嘅相關職責，對進一步完善特區維護國家安全嘅法律制度同埋執行機制，以及有效維護國家安全有重大意義。釋法體現咗法治原則。全國人大常委會作為國家最高權力機關嘅常設機關，按憲法同埋香港國安法對法律嘅解釋有最高權威性同埋約束力。而香港特區法院按基本法獨立行使審判權同埋終審權，呢一個憲制安排，充分體現咗全國人大常委會嘅釋法權同埋香港法院嘅獨立審判權同埋終審權，喺特區法律制度裏邊各自履行佢職能嘅法治原則。釋法亦都清晰展示咗香港國安法同特區現行嘅普通法制度嘅銜接同埋兼容。國家安全係頭等大事，維護國家主權、安全同埋發展利益係一國兩制方針嘅最高原則。香港特區堅決維護國家主權、安全同埋發展利益，堅決維護香港國安法嘅權威，堅決依法履行維護國家安全嘅職責同埋義務，確保一國兩制行穩致遠，香港長期繁榮穩定。
現在係記者答問嘅環節，請你先講出你代表機構嘅名稱，每位請發問唔多於2條嘅問題。前邊白色衫。
特首你好，明報，我有2個問題。第一呢，喺就住呢個國安法嘅47條嘅嗰個判斷呢啲涉及國家安全行為嘅問題嘅時候呢，其實係由邊個去判斷？係由法院啦，定係你啊，即係或者國安委呢？咁幾時需要即係幾時去判斷呢啲行為嘅之前係咪可以司法覆核嘅呢？同埋會唔會引起即係外界嘅擔心？譬如國安委係隨時可以介入一個刑事嘅審訊，譬如講被告係咪可以獲釋啊？海外嘅法官將來係咪可以參與國家安全嘅一啲案件啊？呢啲都可能會引起所謂國安委嘅釋法嘅問題呢。第二呢，就係你頭先提及會即係修改翻嗰個法律執業者條例嗰個本地嗰個規例啦。呢個修例呢，係咪只係針對海外冇本地執業資格嘅律師，定係會可能其他本地律師都有一個審查嘅機制呢？政府整體嘅立場上嚟講，對呢個海外律師嘅制度係咪仍然歡迎佢哋嚟參與一啲即係其他嘅刑事或者民事嘅案件呢？唔該。
根據國安法第47條。佢個條文呢係清晰講咗呢，嗰個 有關認證嘅問題呢，係行政長官會發出呢一個證明書。咁當然嗰個決定權就喺行政長官嗰度嘅。但係行政長官作出呢個決定嘅時候呢，當然係會充分考慮所有因素，特別係行政長官掌握到嘅事實同埋資料，從而去判斷有關嘅行為是否涉及國家安全，又或者有關嘅資料是否涉及國家秘密。咁呢個係行政長官決定嘅，而呢一個嘅決定權力，其實喺香港國安法頒令實施嘅時候，已經係喺條文裏邊清晰講咗啦。所以呢個呢，今次嘅釋法呢，喺呢方面係冇增加任何行政長官嘅權力嘅。咁國安委呢，喺佢嘅權力呢，亦都清楚喺我哋國安法第14條裏邊呢係講述咗嘅。而國安委作出嘅決定呢，剛才所講喺釋法裏邊呢係講得好清楚啦。佢作出嘅決定呢係有呢個法律效力嘅。咁但係呢，喺國安委作出任何決定，當然啦，佢係會充分考慮喺法律條文裏邊，包括基本法，包括香港國安法以及本地法律裏邊呢所涵蓋嘅範圍嘅。所以佢嘅決定亦都必然係會符合法律原則。另外，剛才你所講國安委有關釋法嘅權力呢係不正確嘅。國安委係冇釋法嘅權力，釋法嘅權力呢只係喺人大常委會。剛才我都講清楚，係根據憲法、根據香港國安法而對於香港國安法作釋法嘅，所以國安委係冇釋法權嘅。另外，我哋所提及嘅今次要處理冇本地全面執業資格嘅海外律師呢，去針對所講嘅呢係涉及國家安全嘅案件嘅。咁所以呢，所涉及嘅範圍呢係好窄嘅，而香港絕大部分嘅案件都唔係同國家安全有關嘅，因為自從國家安全香港國安法頒令實施之後呢，香港喺維護國家安全方面呢，整體喺執行方面呢係有成績嘅，所以香港社會呢已經回復咗穩定。涉及香港危害國家安全嘅行為同埋活動呢，好多呢都係喺我哋睇到喺2019年所發生嘅危害國家安全嘅活動同埋行為而引申出嚟嘅案件嘅。所以涉及國家安全嘅案件已經係屬於我哋整體罪案嘅小部分。我亦都相信喺我哋繼續有效落實香港國安法呢，危害國家安全嘅案件呢，應該呢都會減少嘅。而海外嘅律師喺其他嘅案件，即係不涉及國家安全嘅案件呢，我哋係無任歡迎嘅。因為呢，事實上過往海外嘅律師只需要佢哋攞到專案嘅許可，就可以參與我哋一般嘅刑事案件嘅，又甚至係其他案件嘅。所以喺我哋所講嘅，只係針對緊涉及危害國家安全罪行嘅一個範圍。另外一樣嘢就係今次喺釋法裏邊呢，佢係提出咗喺涉及乜嘢行為係涉及危害國家安全嘅認證問題。咁跟住呢，國安委係有個職責去判斷同埋作決定 是否係涉及國家安全嘅行為嘅，而作出咗嗰個判斷同埋決定係乜嘢呢？都係要按住面對嘅事件決定嘅細節呢，都未必係一樣嘅。咁所以呢，我哋係喺非涉及國家安全嘅案件裏邊呢，無論嗰個我哋將來嘅法律修訂係點樣呢，我哋都唔影響代嘅律師喺當佢哋獲得法庭批准嘅專案許可之下，參加非國家安全行為罪行嘅案件嘅。所以咧，我哋要明白今次係所針對性嘅咧，係一個好指定嘅範圍啊。咁我哋完全係歡迎海外法官喺符合要求而又係獲得法庭批准佢專案許可嘅情況之下呢，嚟到參與香港嘅法律工作。
好，下一條提問。前邊黑色衫西裝。
行政長官你好，中央廣播電視總台記者。回歸25年嚟呢，全國人大常委會6次對基本法作出解釋，涉及到居港權啦、政制改革啦、特首任期等等問題。咁人大釋法可以話已經成為咗香港回歸之後法治嘅重要組成部分。咁你認為呢，全國人大本次釋法呢，佢點樣能更好咁去釐清到香港國安法嘅立法嘅原意同埋目的，去確保國安法喺香港得到完整準確嘅落實呢？唔該。
首先喺香港國安法頒令實施之後呢，大家都睇到呢，整體香港嘅危害國家安全行為係受到控制嘅。香港社會呢，大致係回復平穩安全，市民呢，可以係進行自己日常嘅正常嘅社交活動日常嘅生活等等。所以喺我哋實踐香港國安法嘅成績嚟講呢，我覺得香港整體呢係達到我哋預期嘅成績嘅。咁但係呢，喺國安法頒令實施之後，喺我哋實踐嘅過程呢，出現一啲新嘅問題或者對於有關嘅條文嘅解釋呢，社會可能有不同意見，而全國人大常委就香港國安法嘅條文作出解釋嘅重要意義係咩呢？第一，因為佢係我哋國家嘅最高權力機構嘅常設機構，對於解釋法律嘅權呢係屬於最高權威，而且有約束力，咁係可以一錘定音，唔需要喺社會裏邊咧作出任何爭議啦。呢個第一點。第二點呢，今次嘅釋法呢，你睇到係喺指定範圍，去針對性嘅去處理某一個原則嘅，佢亦都唔係針對個案去作釋法嘅。而呢個原則呢，的確係釐清咗特區喺履行維護國家安全責任方面嘅法律責任同埋法律嘅義務嘅。咁所以呢，對於整個特區，呢個係包括行政機關、立法機關同埋司法機關呢，都好清晰咁等我哋知道喺有關呢方面，我哋真真正正應該點樣履行我哋嘅責任。而且今次嘅釋法呢，亦都明確講咗香港特區國安委嘅責任同埋佢嘅職權。咁所以咧，喺我剛才講咧，我係會積極履行香港國安委喺第14條需要履行嘅職責嘅。咁呢個包括咧，我哋係會好積極咁咧，去針對我哋建立一個完善嘅法律制度同埋執行機制咧，係推動呢方面嘅工作。而今次嘅釋法咧，係正正令到我哋咧，喺面對新問題嘅時候，原則性俾咗一個好清晰嘅內容啦，同埋路徑咧，俾我哋向住履行維護國家安全嘅任務咧， 全力去實施到香港國安法嘅立法原意同埋目的，所以係有助整個特區喺履行維護國家安全嘅責任同埋義務嘅。咁所以我係覺得今次嘅釋法係有重大嘅意義，而且我強調今次嘅釋法咧，完全係體現咗香港法律制度、全國人大常委會嘅釋法權，以及香港法院嘅獨立審判權以及終審權喺個法律制度裏邊咧，係各自履行職責嘅一個法治原則充分體現嘅一個事情嚟㗎，所以係非常正面嘅。
好，下一條提問，前邊電腦黑色衫呢位。
Good evening, Mr. Lee. Some English questions from the South China Morning Post. Firstly, under the interpretation by the National People Congress Standing Committee, the matter of allowing overseas lawyers without the full right to practice in Hong Kong to defend clients involved in national security cases will rest either on the Committee for Safeguarding National Security or on yourself as a chief executive. We want to ask, would Jimmy Lai now be able to apply to employ an overseas lawyer for his case through the courts if he wishes, and what would the relevant procedures be in that case? And also, by allowing the chief executive to have the power to determine whether overseas lawyers are allowed in either the Committee for Safeguarding National Security or via himself through approving a certificate, is this unfair to any potential defendants due to a conflict of interest? And what is, and secondly, you also talked about how the government will raise an amendment to the legal practitioners ordinance. Can we ask what do you mean by this amendment, and also whether or not there would be a timetable on when these amendments would be made? And also, what is your stance on hiring overseas lawyers for national security cases, and why welcome certain overseas lawyers for other types of cases, but not those involving national security? Thank you.
That is a very long, serious question, which actually has broken the tradition of answering two questions. But anyway, I'll try to answer them as fully as possible. Well, first of all, we have to pay attention what actually the interpretation covers on this occasion. It covers 3 points. First of all, it touches on the duty of the Hong Kong SAR National Security Committee's duty and functions. And it also talks about how Article 14 and Article 47 can be used to do the certification of an activity, whether the activity relates to national security or whether the information concerned relates to national secrets. So it is an interpretation to allow us to understand more how the national security law actually means in these areas. So in regard to your first questions about Jimmy Lai's case, the interpretation, first of all, doesn't deal with a particular case. The interpretation deals with principles. The principle of how Article 14 and Article 47 should be applied so as to help Hong Kong solving the problem it faces. In fact, it is a principle that should be applied to solve other problems that may arise in the Hong Kong SAR implementation of the Hong Kong national security law. So it is principle, it is not case that the interpretation deals with. So it will be up to Hong Kong to make use of Article 14 and Article 47 to deal with the case concerned. What it means is, in respect of this case, we are dealing with the issue. I mean the Hong Kong SAR, is dealing with the issue whether an overseas lawyer who hasn't got full practicing rights or qualifications in Hong Kong should be allowed to take part in any national security cases. So it will be up to Hong Kong SAR itself to deal with that issue. That means the Hong Kong National Security Committee will have to examine the issues and then make a judgment and make a decision as to how this matter will be addressed. The second thing is the Hong Kong SAR itself, particularly the government, has the responsibility to fulfill its obligation to protect national security. So Hong Kong SAR government can and should also exercise its duty to look at how and what we can do to address the question whether an overseas lawyer or barrister who hasn't gone full practicing rights in Hong Kong, whether he should be allowed to take part in a national security case, taking into consideration all the risks that may be involved. And then the Hong Kong government should examine the way to deal with it. And equally, the Hong Kong National Security Committee may address a particular issue, making use of the power under Article 14 and Article 47 to address the question. And then after the National Security Committee has made a judgment and decision, then, of course, the Hong Kong SAR government will examine how to implement it. The power of the chief executive to issue a certificate to certify whether an activity relates to national security or any information relates to national secret is a power that has been given to the chief executive since the enactment and the implementation of the Hong Kong national security law. So it has been there on the very first day when the law was enacted and implemented. The chief executive's duty is to look at all the information available to him to make an assessment and then certify whether a particular activity relates to national security or any information relates to national secret. This is to deal with certification. And in any trial, the judge is to examine the evidence and the facts of the case to make his judgment independently. So the certification is a fact that he will take into consideration, but whether a person is to be found guilty or acquitted will be based on the evidence and the facts that are presented in the court for the judge to make his independent judgment, free of interference. The third thing is regarding the examination of legal practitioner ordinance to see whether there is a need to amend it. Of course, the Hong Kong SAR government, in fulfilling its obligation to protect national security, have to weigh on the risks whether such participation by an overseas lawyer or barrister without full practicing rights, looking at the potential risks, and then see whether we should amend the legal practitioner ordinance. When there is a decision to amend it, and of course then it will be through a bill presented to LegCo for it to be considered in accordance with LegCo procedure. But I must emphasize, what I'm talking about and what the issue in front of us is a very small area, i.e., looking at an overseas lawyer or barrister without full practicing rights or qualifications, whether they should be allowed to take part in national security cases. Beyond national security cases, then they are most welcome, provided they satisfied the procedure to obtain an ad hoc admission approval by the court. As regard timetable, we will very quickly look at all the risks, as I have mentioned, and if the decision is made that we should proceed with the amendment, then of course we'll do it ASAP. Your last question is about overseas lawyers or barristers practicing in cases other than national security cases, then I have already answered it. They are most welcome, and there has been the practice before, provided they satisfied all the requirements and procedure and obtained the High Court's ad hoc admission approval.
好，時間嘅關係，我哋答多兩條問題。前邊黑色衫女記者。
係，你好，特首星島嘅。今次釋法咧有兩條，包括國安法第47條咧，就係由特首發出呢個證明書啦，同埋第14條都係嘅國安委都係由特首擔任主席嘅，即係兩條其實都係由特首你掌握最終決定權啦。咁請問你決定嘅準則係咩啦？同埋擔唔擔心你話掌握嘅事實啊，同埋資料唔準確，即係令你嘅決定有誤差啦，同埋你每次決定會唔會首先係向中央尋求意見？同埋另外啦，有議員就話即係可能釋法會出現後遺症啦，令外界擔心香港嘅司法獨立受到影響啦。你預計會唔會出現後遺症呢？你覺得法律界會唔會有反彈？唔該。
第一，第47條所講香港國安法第47條所講嘅行政長官去發呢個證明書，呢個權力喺香港國安法頒令實施已經存在，唔係因為釋法有任何改變嘅。第二，喺第14條，香港特別行政區維護國家安全委員會，佢有不同嘅成員嘅，呢個包括有3位司長，有保安局局長，有3位處長，有特首辦主任，亦都有由中央委派嘅國安顧問。咁所以國安委係由行政長官做主席，但係國安委所作嘅決定，亦都係國安委嘅整體決定，唔係一個人嘅決定嚟㗎。所以國安委嘅決定係屬於國安委成個委員會嘅。當然，行政長官作為主席係有去舉行會議，係推動討論，以及最終呢係主持委員會喺討論裏邊嘅一啲議程，佢哋嘅討論方式。咁但係我必須強調，國安委係一個委員會，而國安委嘅決定係屬於委員會嘅決定。咁所以喺作出任何決定，都一定係充分考慮所有喺委員會裏邊掌握嘅資料同埋一啲實際情況，而最後呢係作出判斷同埋決定嘅。第二呢， 喺我哋處理香港國安法嘅事情裏邊呢，其實維護國家安全係中央事權，中央呢係信任特區，所以授權特區經過香港國安法，授權特區去處理維護國家安全嘅一啲案件。咁所以呢，香港特別行政區喺呢個授權之下呢，係會根據住法律嘅原則以及所掌握嘅證據呢，係作出決定嘅。另外呢，今次嘅釋法呢，我剛才都講啦，係充分體現咗係我哋嘅法治原則嘅。我哋係充分咁體現咗喺不同方面喺我哋香港嘅法律體制裏邊係各自執行職權嘅司法精神，法治精神。呢個包括係咩呢？係全國人大常委會佢嘅按住憲法同埋香港國安法嘅釋法權。而香港嘅法院呢，係按住基本法，亦都係按住香港國安法呢，去行使佢哋嘅獨立審判權同埋終審權。呢個正正體現喺我哋整個香港法律制度喺處理危害國家安全罪行方面嘅履行嘅法治原則。今次嘅釋法充分讓所有人都睇到依法治國同埋香港特區係依法去行事呢一個法治原則同埋法治精神，係對於香港整體嘅法治制度同埋法治原則呢，係有正面嘅作用嘅，亦都有正面嘅意義嘅。所以我覺得今次嘅釋法呢，只會係增加咗市民又或者國際人士呢，去更加了解喺香港國安法嘅實施裏邊，我哋係點樣慎重兼且係重視法治原則，以及係堅持去維護被告人嘅權利嘅。包括佢有公平審訊啦，包括佢喺法律上邊應該享有依法嘅權利同埋自由嘅。咁所以你睇今次釋法嘅範圍呢，亦都係好有指定性同埋針對性嘅一個範圍，係制定原則，唔係處理案件。呢個呢，充分係體現咗喺我哋整個國家安全執法嘅過程裏邊呢，係重視法治原則，所以我會覺得係一個正面嘅作用嚟嘅。而且我相信呢，法律界呢更加重視我哋喺執行任何嘅責任或者職責嘅時候呢，係依法行事嘅。今次呢，正正係依法行事嘅一個好清晰同埋全面嘅表現嚟嘅。
我哋答最後一條問題。後邊粉紅色衫戴眼鏡記者。
Thank you. Good evening, Mr. Lee. 2 questions from AFP. First of all, according to the interpretation, the matter of overseas lawyers representing defendants in national security cases is just one of an unspecified category of national security matters that may up to you and the National Security Committee's assessment. So, even you said that the national security cases is just a very small area. Is it that in that area, the National Security Committee has become a court above all courts in Hong Kong, and you, as the chairman of the committee, has become a judge above all judges? Second question. You said that in non-national security cases, overseas lawyers are still most welcome to practice in Hong Kong. However, we all know that national security cases in Hong Kong do not only cover NSL crimes, it may also cover sedition, for example. So can you once and for all tell all the overseas lawyers what are non-national security cases in Hong Kong? Or, in an opposite way, what are national security cases in Hong Kong? Thank you.
Can you first of all repeat your first question, because you've asked quite a few.
Of course. My first question is, under the interpretation, the matter of overseas lawyers representing defendants in national security cases is just one of an unspecified category of national security matters that you and National Security Committee may assess and decide. So, even you said that national security cases form a very small area, would it be that at least in that area, the National Security Committee has become a court above all courts, and you, as the chairman, has become a judge above all judges?
Okay. Well, first of all, your premise, I have to correct it. The interpretation on this occasion clearly explains the purposes and intention of the Hong Kong national security law by specifying the role of the chief executive in assessing and certifying whether any activity relates to national security and whether any information relates to national secret. And of course, you will know that for a lot of activities, they can vary in the actual execution of what is intended to be done to harm national security. So there will be a variety of actions that may endanger national security, which a country face, whether it is our own country or any other country. Espionage, for example, can take various forms. So it is the duty of the chief executive to certify whether any activity actually relates to national security. So it is this certification which is Article 47 is specifying. This power exists in the Hong Kong national security law since its enactment and implementation. So the interpretation of Article 47 does not create extra power for the chief executive in such certification. The chief executive only does the certification. He is not to rule on a case. All cases are ruled by judges in court in accordance with the law and the evidence and facts in front of the judge. And each case, the defendant is fully represented by lawyers chosen by him who will be arguing the case on his behalf. So the chief executive doesn't play judge at all. So it is a wrong premise, and it's a wrong interpretation. And since the chief executive is not a judge, so there's no truth in your description of anything to do with above the judges, because the certification only aims at certifying a particular activity relates to national security. And the Hong Kong national security law stipulates only 4 offense types. But for activities that endanger national security can be beyond the 4 offense types of the Hong Kong national security law. That is why I have always been telling people that the Hong Kong national security law is a law which addresses only some specific activities which endanger national security. In fact, there are a lot other activities that may endanger national security which are not covered by the Hong Kong national security law. They may be covered in other Hong Kong laws, such as the Crimes Ordinance on treason. The Hong Kong national security law doesn't cover treason, but the Crimes Ordinance of Hong Kong does. So you are right, there are activities which may endanger national security, which goes beyond the coverage of Hong Kong national security law. That is exactly why the Hong Kong SAR government has a duty to enact law to satisfy Article 23 of the Basic Law, and also to improve the system and the legal coverage for activities that may endanger national security. But this will be done through local legislation. And this is the duty of all government of any country to safeguard the country's national security through successful implementation of the laws. Because safeguarding national security is a state's responsibility. And it is the responsibility, I think, of almost all the states around the world. And the Central People's Government has trusted the Hong Kong SAR government to implement laws to safeguard national security. And we have to do it to fulfill our obligation, because under the Hong Kong national security law and also under the Basic Law, we have this constitutional duty. Thank you very much.
記者會結束，多謝大家。